Representative Herr, thank you very much. We're clipping along with some very scintillating policy bills this morning, but now we're on to your bill. So I will move to recommend House File 1625 be re-referred to the Labor and Industry Finance and Policy Committee. I do see you have an A1 author's amendment, so I will also move the A1 amendment. Representative Herr, if you can just clarify what that A1 amendment does.
The A1 amendment was just fixing an oversight of when we had the bill redrafted from a 2020 date to 2024 date. So it's
yeah, changing the effective date to somewhere in the past is interesting. Okay, so all those in favor of the A1 amendment, please say aye.
Aye.
Opposed? The motion prevails. The amendment is adopted. Representative Herr, please tell us about your bill as amended.
Thank you, Chair Becker-Finn, and I hope that when I walked in, you weren't laughing at me, you were laughing with me, or you're laughing at something else that had nothing to do with
For the record, we were laughing at Representative Carroll's very funny lawyer joke about the rule against perpetuity, so it had nothing to do with this very good bill that's in front of us.
Thank you so
Representative
much.
Herr.
Thank you, Chair Becker-Finn and members. This morning, I'm presenting House File 1625, the Preventing Pay Discrimination Act. I think this is the first time I've been in front of this committee to present a bill and not being part of the committee. I was on it for 4 years, but it looks like the committee is in good hands with all of these great members. This bill is actually not new to this committee. This bill actually passed out of Judiciary and out of Labor last biennium, and it was heard as a standalone bill in the House floor and passed with bipartisan support on a vote of 80 to 51. So this bill is very straightforward. It simply prevents an employer from asking what a job applicant's pay history is when they're negotiating their salary. However, this bill does allow a job applicant to voluntarily disclose their pay history, and if they do so, then the employer is allowed to use this information as necessary. Above all else, House File 1625 takes us one step closer to closing the pay gap in Minnesota. The pay gap in Minnesota is very real. I'm not sure the last time the statistics were presented in front of this committee, but women get paid 80 cents on the dollar for what a man makes. This drops even lower for women of color. Asian women make 71 cents on the dollar, and when you disaggregate that, Southeast Asian women actually make closer to 50 cents on the dollar. Black women make 59 cents on the dollar, and it's even lower for our Somali women. And Indigenous women make 56 cents on the dollar, and Latinas make 53 cents on the dollar. So with House File 1625, we work to close the pay gap by saying that a job applicant can no longer be forced to disclose their pay history during their salary negotiation. Some of you may be wondering why and how this contributes to the pay gap, but to help close the pay gap, this helps close the pay gap because the pay history question can give an employer a built-in excuse to pay a job application less because they are basing that decision off of someone's past history. The reason why they can do this is because the 1963 Federal Equal Pay Act actually facilitates the pay inequity. Employers sued under the Federal Equal Pay Act for paying women less will commonly defend their unequal pay practices by contending that they set salaries by relying on each job applicant's pay history. The United States Courts of Appeals from the 8th Circuit, which covers Minnesota, has accepted this argument, holding that it does not violate the Equal Pay Act for an employer to pay women less if the employer determined pay scales by relying on pay history. By ending the pay history question, a job applicant's future wage will no longer be anchored down by their past, and we can break the cycle of discrimination that can follow women and BIPOC sometimes throughout their entire careers. It's also important to note that 18 states, including Alabama and North Carolina, have already passed their own pay history question bans. In 2020, a study by research at Boston University School of Law found that enactment of state pay history bans actually closed the pay gap 5 to 6% on average, and for female job changers, this increased their pay by 8%, and for African Americans, that was by 13%. In other words, adopting the pay history bans reduce both gender and racial wage gaps. It's time for Minnesota to step in to close the gap, to close our gap. So with me today, Chair Becker-Finn, I do have Commissioner Lucero from the Department of Human Rights to testify in favor of the bill and to answer any questions that you all may have. So if she is here, I'd love to bring her up.
Commissioner Lucero. Welcome back to the committee. Please introduce yourself and proceed with your testimony.
All right. Good morning, Chair Becker-Finn, members of the committee. My name is Rebecca Lucero, and I'm the Commissioner for Minnesota Department of Human Rights. It's good to be back here with you this morning. First, I want to thank Representative Herr for carrying this agency policy bill and to the committee for giving the bill a hearing. So House File 1625, otherwise known as the Preventing Pay Discrimination Act, will help close Minnesota's gender and racial pay gap. As Representative Herr explained, it prevents pay discrimination from taking place when a Minnesotan applies for a job or negotiates their pay. It simply says, don't ask an applicant to disclose their pay history. Now, there are 3 reasons why it's important to be intentional about eliminating the pay history question. So first, women are consistently paid less than men with similar experience, qualifications, and seniority in the same position. And that pay gap increases for women of color and Indigenous women. And Representative Herr provided some of those really concerning statistics around that. Now, there are many reasons why this exists. And one of the things we should do is start by looking at the structural systems that contribute to this outcome. So Professor Hasday, a law professor for the University of Minnesota, has joined us several times over the year, not today, but several times over the years, to testify about this bill. And she always starts her testimony by sharing that before 1963, it was perfectly legal for employers to pay women less. And it was, in fact, the norm to see help wanted ads that would list one salary for men and a lower salary for women for doing the exact same work. So the Preventing Pay Discrimination Act helps break this systemic discriminatory cycle that has not yet ended. Secondly, the gender wage gap persists even after the passing of the Equal Pay Act. And in fact, in Minnesota, we have not narrowed this over the past 5 years. So why is that? If an employer is supposed to pay men and women the same for the same work, why isn't that happening? It isn't 1963 anymore. And yet the same results of paying men and women differently persist, especially for women of color. So one important reason for this persistent wage gap is that employers frequently ask job applicants about their pay history before deciding what salary to offer. In fact, employers oftentimes ask it as part of the initial application, long before an interview has occurred, meaning that they're actually even taking that information into consideration about who should even receive an interview. So to be intentional about closing the gap, we look at what policies or practices, what formal policies and what informal policies are perpetuating this inequality in pay, resulting in this discriminatory outcome. The use of the pay history question is one of these practices that is neutral on its face, but in practice often causes inequality in pay. Again, if Professor Hasday was here, she would remind us, in echoing comments by Representative Herr, that in Minnesota, it does not violate the Equal Pay Act for an employer to pay women less if the employer determined pay scales by relying on pay history. This means that without this bill, an employer can pay a woman less than a man for doing the same work, so long as the employer can point to the woman's pay history as a basis for that discrimination, this discriminatory outcome. Again, this means that someone can be locked into this cycle of unequal pay that will impact them throughout the rest of their lives. The Preventing Pay Discrimination Act, again, aims to break this cycle. So the third reason is it works. In states that have eliminated the pay history question, they saw an 8% increase for pay for all women and a 13% increase for pay in Black workers. This is good for Minnesota. Now, I've had the pleasure of testifying about this bill multiple times, as you know, and when I do, I usually get a couple of key questions that I'd like to address. So the first question I get is, hey, how does this bill relate to current discrimination law? And I want to make sure that I'm providing that information, that this bill is fully aligned with the rest of the Minnesota Human Rights Act, as well as federal law, which often requires a burden-shifting analysis when deciding whether or not discrimination occurred. So right now, when someone contacts our office, they have to show that they have what's called a prima facie case. They have to meet the prima facie elements, alleging facts adequate to support their legal claim. At this point, the burden shifts to the employer to articulate a legitimate, non-discriminatory reason for what occurred. And if an employer is able to show that legitimate, non-discriminatory reason for what occurred, the burden then shifts back. So there's this back and forth burden shifting. So for this bill, this means that if an employer uses a job applicant's past pay to set their wages, then it will be the employer's responsibility to explain why did they do that, which is in alignment with discrimination law today. The second question I get often is this difficult to comply with? Nope. This is a simple bill to comply with, which is demonstrated by the fact that many employers have already started making this change because they understand the importance of this. This is easy for small employers and big employers in the exact same way that employers cannot consider, for example, if someone is or is not pregnant. They also would not be able to consider previous pay. I myself have hired many employees myself throughout my career, and it's easy to comply. I simply do not use salary history when making an offer. So when someone applies for a job, I consider their qualifications, I consider their experience, I consider whether or not they have any relevant education experience. I certainly consider the market, but I don't ask if they're pregnant. I don't ask about their age, and I don't ask about their salary history. In closing, I want to highlight all the support that exists for the bill. That includes the Minnesota Council of Nonprofits, Min Legal Aid, and Girl Scouts of River Valley, all of whom speak about how important it is to close the pay gap. When Minnesota passes this bill, we will join a groundswell of over 20 states that have already ended the pay history question and will bring Minnesota one step closer to closing the pay gap. Thank you very much for the time, and I stand for any questions.
All right. Are there any other members of the public wishing to testify on this bill? All right. Not seeing any, we'll move on to member discussion. Representative Finke.
Thank you, Chair Becker-Finn. I know that we're pressed for time, so Representative Herr, and Commissioner Lucero, I'll just put a quick plug in for expanding our data collection so that we're making sure we are collecting data on all members of our community, and point out that trans women make about 60 cents on the dollar to men, and this is an extremely important bill for our community. Hiring trans people is not an act of charity, and we deserve to be paid just like everyone else.
Thank you. Representative Curran.
Thank you, Chair, and thank you, Representative Herr, for bringing this forward. I know this has been heard in the body before. It's my first time, but when I saw this, I was really excited. I know we have attorneys that giggle and geek out over some of the stuff in this committee, but I also am a human resources nerd. So I worked in human resources for several years. I interviewed hundreds of applicants, and what I noticed time and time again is that past pay has absolutely nothing to do with skill level, competency, anything like that. It's, in my mind, asking for pay history is really just fishing for cheap labor and not looking at the best possible work and actually just honestly paying for the work that needs to be done. And I think that's where we need to head. And so I appreciate you bringing this forward from that perspective.
Right, thank you. And I'll say in my experience interviewing people too, I did want to point out subdivision C, that if the applicant were to disclose because they think maybe disclosing that they make more money at their current job as a negotiation, that there is a ability, if the applicant thinks that it's going to help them in their negotiation, they do have the ability to do that under this, this language of this bill. Next on the list, I've got Representative Johnson.
Chair Becker-Finn, Representative Herr, I'm just wondering how this is going to affect our state's largest employer. The state of Minnesota and our local governments and school districts and colleges combined is the largest employer in the state of Minnesota, well over 400,000 employees. And by statute, all their salaries are public. So their information is out there, but they can't, but on this bill, it can't be disclosed. How is that going to mesh with this program?
Well, I can actually, Representative Johnson, I'm going to point you to line 1.17, and then I'm going to go to Commissioner Lucero. Go ahead.
Great. Chair Becker-Finn, thank you very much, Representative Johnson, for the question. So in great news, the state already does not consider past pay as part of its analysis. So right now, when I work to hire people, there's a whole analysis that I do based on their level of education, what else is going on in the market, et cetera. And I fill out that form, and that's how I make my basis. It is really well defined that way. Now, of course, both if you are a current employee, if you're a current employer, private or public, or the information might be out there, that is outlined in here. And so there are many things that you might know. You might know, for instance, that somebody is pregnant. You cannot use that in determining their salary. You might know their age. You cannot use their age in saying, actually, I don't want to hire somebody of that age. And this is saying you might know what their salary is. You can't use that in determining what their current or future salary will be.
Representative Johnson.
Chair Beckerfield, I just want to make sure that people understood that even though a salary is public information, when they're looking at hiring somebody, they can't use it. But that goes in, that can be two ways. I'm going to take a very good friend of mine, was offered a different job. It was 40 miles one way less driving, but a 65% decrease in pay. It would have been a lot larger decrease in pay, but they knew that person's salary, so they bumped it up dramatically to get that person to come and work for them, which is now only a 2-mile drive from where they live. So sometimes it can work the other way. Knowing the salary that they're at can actually, when they're looking at changing jobs for different reasons, can actually increase their pay. So it works both ways. So it's just something to consider. I understand this, and I understand why we want to do this, but we got to also remember it can work both ways.
All right. We've got a couple members on the list, so I'm going to keep going. Representative Niska.
Thank you, Madam Chair, and thank you, Representative Herr. My question really is focused on the rebuttable presumption language and starting in line 1.13, and I'm curious as to whether the other states in which this is done also use a rebuttable presumption like this, and whether that's necessary to reach the goals of the statute.
Commissioner or Representative Herr?
I would give my response of maybe around law schools, but I think Commissioner Lucero might be a better person to answer the question.
Commissioner.
Chair Beckerfin, Representative Nesbitt, thank you for that. So there are over 20 states that have moved on this kind of ban, and there's different ways that states have enforced this policy. Some states took a civil penalty route, some states take more of a discriminatory analysis route. Here, we have taken a discriminatory analysis route, and that means that if an employer is found to be in violation, it will be their responsibility to explain why they used the pay history question to determine a job applicant's wage. So it varies across the country.
All right, follow-up, Representative Niska.
Yes, thank you, Madam Chair, and Representative Lucero. Of the states that do use this,
I'm happy with my job.
sorry, Commissioner Lucero. Commissioner Lucero, following up on that, you said that some states use the discriminatory statute or approach. What are there other states that define it as a rebuttable presumption using this kind of language? That was my question.
Commissioner.
Sure, Chair, Representative Nisbet. So rebuttable presumption is a standard concept in anti-discrimination law, and I hope I provided some context to that in my testimony. It's very familiar, completely standard in employment and labor law, and it provides clarity on what the next steps will be and if an employer is found to be in violation of the law. So if an employer used a job applicant's past pay to set their wages, it's their responsibility to explain why they did that. The rebuttable presumption language sets that clear standard for employers and job applicants and makes it easy for instance, small employers to know exactly what is being asked of them and what's being prevented of them from being asked.
Representative Niska.
Thank you, Madam Chair, and Commissioner. I still am not sure that you answered the question about other states' salary pay history laws. And I agree with you that the burden shifting standard in federal case law, it's a McDonnell-Douglas standard, is common. What isn't common, from my understanding of both the Minnesota Human Rights Act and federal human rights laws, and I'm not sure other states' discrimination laws, is that we have a statute that calls out something some particular thing as being a rebuttable presumption of discrimination. And I'm really concerned that what we're doing is putting something different into that burden shifting standard than what exists already in all of the other situations, and creates a problem in which employers who aren't discriminating have a much harder time of establishing that they weren't doing something discriminatory. And the way this plays out in actual litigation is that that makes it much harder for someone who has a meritorious reason why they did something to get summary judgment. And that results in them essentially having to settle cases that might not be meritorious and might otherwise be shaken out at the summary judgment stage. And so I am really concerned that we're doing something anomalous and different in the statutory language that is going to create some really serious problems for good employers who aren't trying to discriminate. And that's the question that I'm getting at. And I would like some comfort that there is some other statute somewhere that uses this kind of rebuttable presumption language without creating those kind of negative consequences.
Commissioner.
Thank you, Chair. So I appreciate the concern with putting something different in. So the Minnesota Human Rights Act also follows the burden shifting McDonnell-Douglas test. It's not just at the federal level. So this is putting in place exactly what is right now the law that requires that when an employer does something, that they have a burden to articulate a legitimate non-discriminatory reason for why they did that. They have the burden to do that, whether that is discrimination based on age, discrimination based on race, sex, or here, whether regarding pay history question itself. So that is what is the law at the moment. Nothing different.
Follow-up, Representative Niska.
And thank you, Madam Chair. Just a follow-up comment, which is that we're using different language here than we use anywhere else. And so I'm very concerned that district judges and Court of Appeals judges and the Minnesota Supreme Court judges, when they read the language of the statute, are not going to just interpret this as being the same standard that they apply when we use different language, not defining something as a rebuttable presumption of discrimination. So I hope that we can find some way to write this in a way that's consistent with the rest of the Human Rights Act that also applies the burden shifting standard, and not create a situation where good employers are going to get caught up in a litigation trap.
All right. Representative Scott.
Thank you, Madam Chair. Representative Lucero, thank you for being here again.
Still not.
Oh,
Not senator.
I know, old habits, sorry.
It's totally okay.
Yeah, and I just had gotten a text from
Representative, yeah. We all miss him. Representative Scott.
Thank you, Madam Chair. Commissioner Lucero, I guess it's a contagion here. It is early. I'm just having a hard time, based on the back and forth that you two just had, Representative Niska and Commissioner Lucero, I'm having a hard time squaring away why we need the rebuttable presumption language when you're saying already that this is how it goes in your department and in these human rights cases. There's the burden shifting back and forth, and I'm just I can't understand. It seems duplicative to me. That you're putting this rebuttable presumption in on top of what you just said is the way you sort of operate anyway.
Commissioner.
Chair Becker-Finn, Representative Scott, thank you very much for the question. Okay, and so first off, the Minnesota Human Rights Act is over 50 years old, and it is heavily based on both the act itself and substantial case law. So when we're putting in something like this, that's really getting at the systems that are in place. It's different than, it's a slight difference than how you think about discrimination law. This is getting at systemic issues. And so here we just want to be very clear about what the responsibility is. This is also about, I want to make sure that there isn't any uncertainty, especially for maybe employers that don't have an HR team, to be able to say, what is the burden here? And the burden is on you to be able to demonstrate a non-discriminatory reason for why you would have asked for that, that makes it very easy for courts, in fact, to align it with the other burden shifting process, because we don't have this in Minnesota right now. So it will be kind of a first impression to a certain extent when it comes up. So this makes it clear.
Representative Scott.
Thank you, Madam Chair. Commissioner Lucero, does case law back up, I guess, because some states use case law, right, in this, and rather than put it in the human rights portion of their statutes, they go by case law to determine these cases. That's my understanding anyway of what other states have done.
Commissioner.
Chair Beckerfin, Representative Scott, my understanding is that there are over 20 states that have specifically put something within their laws. And then the laws, the human rights laws or civil rights laws, rely on a lot of case law in interpreting and understanding them. So I think if that helps clarify.
Representative
Thanks,
Scott.
Madam Chair. And so I guess I'll just end by saying we all want pay equity, right? It shouldn't matter, man, woman, whatever. Everybody wants pay equity, and I think that's what this bill, what we're really trying to accomplish with this bill. And I just think putting that that presumption in there is the obstacle here for many folks, especially small employers who don't have their own HR department, who are trying to act in good faith. And I know Representative Niska asked you several times what other states are doing, and I do believe that we would be the only state that would have this rebuttable presumption. And so I think that's what gives us pause on this. I think that it would be 100%, it would be a unanimous vote if we didn't have that presumption there. And it's just, I'm still not understanding that it's really necessary for what's already the way that the Department of Human Rights operates on these sorts of cases. So thank you, Madam Chair.
Thank you. And I can say, as the HR department for my small business, it's, I think, making it really clear, just don't ask. Don't ask and don't use this as you determine wages for folks. So, I mean, I actually appreciate the very first sentence on line 1.10 is very clear of what we're supposed to do. And I think that's, Representative Herr, obviously, I'll go to you to close out, but I think that's the idea, is that we're making it really clear in statutes that we're not relying on courts to then make decisions so that then we can apply things further down the line. We're being very clear in what we're trying to do in the statute. But Representative Herr, if you want to close us out.
Thank you, Chair Beckerfin and members, for hearing House File 1625. I really do appreciate the opportunity to bring this bill in front of the committee again, and I just wanted to address a couple of points really quick. Representative Johnson talked about public employers and that being actually public data. The truth is that we do see that in the public sector there's less of a pay gap issue because those salary ranges are actually put out there and they base it on your education, your experience. And so when you look at the data of public employees, they actually have very little pay gap, if any at all, depending on whatever industry they're in. So the concern around public entities, I think, is for us, we don't actually have to worry about that, right? And the other issue around this rebuttable presumption is that if it is, I guess I'm confused as to if this were out, there'd be 100% vote on this, but if this is in, what does it hurt? If we set standards, every state has different laws that are slightly different, and that if we don't take the opportunity at times to be more clear or to be more succinct at what we're trying to do in the message we're sending, then we really have missed the opportunity to say what if states are. Same thing as we're doing with the marijuana laws, that where we saw our cannabis bill is that where we see where it's been, it hasn't worked, we change the language. They're not all the same across the state. And so when we have the opportunity to make a law better, we should. And this is the opportunity to do that. And so, yes, other states may not have this, and we will, and that'll make us a better state for doing so. So I just ask this committee support for this bill, and so that we can move it forward and get this finally passed so that Minnesota can start being more equitable in its pay. Thank you, Chair Beckerfin and the committee.
All right, thank you. Seeing no further discussion, I will renew my motion to re-refer House File 1625 as amended to the Labor and Industry, Finance and Policy Committee. All those in favor, please say aye. Aye. Opposed? No. The motion prevails. Thank you, Representative Herr.